Good afternoon, guys. Good afternoon, and welcome to today's edition of The Law and You. I am your host, Shellon Washington, attorney at law, licensed in the state of New York, in the country of Guyana, and also in Trinidad and Tobago. It is my pleasure to be here once again, another Saturday afternoon. And this afternoon, we will be discussing medical malpractice issues, some of the issues you need to be aware of in case you got injured by a doctor or by a medical facility or a hospital. So I hope that those of you watching take notes in case you know a family member, a friend, anyone who might be injured as a result of the mistake of any doctor, medical facility, or hospital. Again, I am Shellon Washington, owner and founder of the Washington Law Firm. Our office is located at 455 Utica Avenue in Brooklyn, New York. If you do have an issue, a medical malpractice issue, our firm is specialized in medical malpractice. So let's get into it this afternoon. Now, I know some of you, a couple of times, people have contacted me regarding issues they have faced with their doctors. They believe that they were injured. The doctor might have done something, and they might have believed it was wrong. Now, let me explain to you guys, not every wrong demands compensation. So there are instances when a party receive some sort of injury at the hands of a doctor, but it's not necessarily compensatable. Now, because there's a couple of intervening factors, which we will take a brief look at. As you know, the show only runs for 30 minutes, so there's not much we could get into as it relates to your medical malpractice case. Now, in a medical malpractice setting, if you believe that you are injured by a doctor or a nurse or any hospital, one of the first thing you have to do is get examined, get a second opinion. So, for instance, if you had a surgery and you believe that after the surgery, you discover that you are injured, you discover that you never got better, but in fact, you got worse at the hands of the surgeon or the doctor, whoever performed the surgery. One of the things you should always do is go as quickly as you can and get a second opinion from a doctor in the same specialty. Now, with medical malpractice, you could only have a doctor charged with something that he or she is specialized in. So, for instance, if you are thinking about a urologist and you're injured, let's say you're a male and you're injured, you did a prostatectomy or some sort of male procedure, and you receive some sort of injury at the hands of the doctor. The rule is you must also seek a medical doctor who have the same specialty to get your second opinion from. That doctor who gives you the second opinion is likely to tell you whether or not there were errors, mistakes, or something else that occurred during your surgery that resulted in injury to you, or whether or not there's something special about you that may result in a certain type of injury to you. And these are things, assume risk. There's something called an assumed risk. So for every surgery procedure that you would have done with a hospital, with a doctor, they are required to disclose the risk associated with those procedures or surgery. And if they fail to disclose those risks and you go and they perform those procedure or surgery on you, and it resulted in injury to you, then you are entitled at some point, if you can prove that you were in fact injured and your injury resulted in damages to you, then you may be entitled to some sort of compensation, damages from that doctor, hospital, medical facilities, whatever it is. Now, the rule is, which I've also told people before in previous videos when I previously appeared on 107 .1 FM, Benchtop Radio. I explained to you guys one of the things about medical malpractice. It's a very costly area of law. Hence, it's not a whole lot of attorneys who practice medical malpractice. I'm fortunate to be one of those who practice medical malpractice, but medical malpractice cases are not that common, and you don't see them around every day, because not every person who will show up at the office and say, "Hey, I got injured. The doctor performed this surgery on me, and he never explained the risk, or he never did this," doesn't necessarily mean that you are actually entitled to compensation. One of the first thing I said to people, if the city, because in New York, a lot of people from minority communities often visit hospitals which are state owned or owned by the municipality, like Kings County Hospital. Kings County Hospital is owned by the county. It's a county hospital. So you already know, and people have reported a large number of incidences at that hospital. It's not very highly rated. So if you know that you go to Kings County Hospital and you receive some sort of injury, the time is against you. The clock is ticking, because the rule is, the law says you only have 90 days, first of all, to report that you intend to sue. You intend to sue the county because you sustained some sort of injury as a result of the negligence of a doctor. And after that, if you could serve that notice timely, the second aspect of this, you must also beat the statute of limitations. So with any municipality or state issue related, once you serve that notice, a hearing is usually held, because the municipality wants to investigate. They want to make sure that your claim actually has merit, and they can get the information from all of the employees who were involved up front, so that they know exactly what they're dealing with. And if you miss that 90 days timeline, that's it for you. You cannot sue anymore. The only way you can get around that 90 days deadline is if you bring a petition before the court asking to file your notice of claim out of time. And the standard to have the court allow you to do this is very, very tough. It's a difficult standard to overcome. One of the issues, if you were a minor at the time of the incident and therefore you didn't file the notice of claim within the 90 days, chances are you can overcome. Or if you were in a coma, you were very sick in a coma, there are limited circumstances under which I saw that the court was willing to extend the time to file that notice of claim. So it's very imperative that if you intend to bring a medical malpractice against the state of New York or against the city, the county, any of the sort, you must ensure that your 90 days notice of claim is timely filed. The state, the city, they do not play with that 90 days rule. It's strictly enforceable. So, and like I said, it's just literally limited circumstances under which you can actually get around that rule. So you have to be very careful. And the other aspect of medical malpractice, which a lot of people are not familiar with, in New York and New Jersey, what we do is the affidavit of merit. Now, the affidavit of merit, you can bypass that in the beginning with a medical malpractice in New York, but in New Jersey, it's strictly mandatory. You have to have that affidavit of merit within a specific timeline. Otherwise, your case is going to be dismissed. The court's not going to entertain it. If you don't file an affidavit of merit after you file your complaint, telling the court that your case has merit, a doctor has examined you as the plaintiff, and the doctor himself, who is also in the same area of specialty as the doctor who caused your injury, is of the opinion that the doctor who caused your injury fell outside the standard of care. They fail to perform the required standard of care and is therefore responsible for your injuries. Of course, there are defenses to medical malpractice, and those are things that we will get to at some point. But what I would like to focus on right now is, the how do you get compensated if you got injured by a doctor. And one of the things is you got to understand is most doctors facility, or I should say all of them, has medical malpractice insurance. There are limited instances where somebody might make their insurance lapse, and that's against regulations. So every single doctor practicing, every single medical facility, every single nurse, they must have medical malpractice insurance. And it is the insurance that covers your injury, not really the facility. That malpractice insurance is what pays out if something should happen, if the doctor should make a mistake, if the nurse should make a mistake, if the facility should make a mistake. And one of the things you have to be careful of, a lot of times what happens is doctors are associated with a facility, but they're not necessarily employed by that facility. They enter into some sort of contract with those hospitals, but they're not employees, direct employees. So there's not the agency rule doesn't apply. The agency rule is where the hospital has a direct employee agent, where the employee is the agent of the hospital, and they're therefore acting on behalf of the hospital, and any actions on their part the hospital is responsible for. And then a lot of times in medical malpractice, we want to get the hospital, because the hospital insurance, malpractice insurance, is usually higher than that carried by an individual doctor. Some doctors is capped out at maybe like $1 million or $3 million, the max. But if that policy is capped, that's a problem, because if you're seriously injured, you're looking to walk away with something in the millions. You don't want to walk away with maybe a couple of hundreds of thousands of dollars or 800,000. You want to walk away with a substantial amount of money. And the policy is what helps you to get there. If it's comprehensive, if it's like a $10 million policy, that's what the kind of thing you would like to ideally see with a facility. And when you're suing a hospital, in the hospital itself, some facilities carries its own independent malpractice, but in most instances, the individual nurse, the individual doctor, they carry their own medical malpractice insurance on them, so that if they make a mistake or they commit negligence, that policy is what is going to cover that individual doctors or nurses' negligence that they would have done. So if you're looking to be compensated, first you need to do, just immediately after the accident or the injury, the surgery, whatever it is, consult an attorney. Do not wait. Consult the minute you recognize, because I can't emphasize enough how many times the statute ran on people. If it's the city or the state, the 90 days ran on them, and then they wake up and realize, I should have sued. There's one thing else I need to tell you. Sometimes you don't readily discover your injuries. Sometimes it takes years for people to discover like they're injured. Like in some instances, this happened quite a few times, where medical equipment apparatus that they used during the surgery was left in the body of a person. It was sewed up inside of them, and the person was completely unaware. And a few years down the line, they started experiencing problems. Then they go and get an x-ray done, and then it's discovered that a negligent doctor or a nurse sewed up the person's wound with a medical apparatus that was used during the surgery. In those instances, even though the statute would have ran on you for medical malpractice, the law is going to allow you to use what is called the discovery rule. The discovery rule is in New York and New Jersey. So you do not need to worry if you discovered 2 years down the line, 3 years down the line, that, oh no, you've been injured in a medical malpractice case by a doctor or some nurse or somebody left a medical apparatus in you, but you just didn't know. And you've been feeling pain, you've been feeling something in that area, but you weren't sure. And you discovered it, let's say 4 or 5 years down the line. The law says you're still entitled to sue that doctor, medical facility, hospital, whatever it is, because of the discovery rule. The time would start to run from the time you discovered your injury versus starting to run, at the date the injury actually happened. Because there was no way for you to discover what a doctor or a nurse closed up your wound, the area that they did the surgery on, that they actually put an incision on and performed a surgery. There's absolutely no way for you to discover that they left an apparatus inside of you. And that has happened in numerous, countless cases here in the United States where people have reported this sort of horror that they have discovered years after that a medical apparatus was left inside of them and it was causing them pain and discomfort, and they didn't know what it was. But some intelligent doctor later down the road did an x-ray and discovered that this apparatus was left in the person. So you just have to be mindful of that even if you discover it too late outside of the statute of limitation, that you still have the right to file a claim against that doctor or hospital, whoever it was, because the discovery rule would have preserved the statutory period for you. So you would have been fine. Another thing people need to understand about this, medical malpractice is one of the most expensive form of law to practice. And this is why the people who practice the area is so small. It's a very small pool of attorney that does it because it's extremely expensive. When you come to my office with a medical malpractice claim, the first thing I have to do is send it to an expert. I have to find an expert, which we usually find through agencies. They're expert institutes that actually finds experts for us. And once we discover that expert, the next thing we do is the expert has to review the file. Once the expert reviews the file, they tell us, okay, your case has merit and you could proceed. And I think a lot of people miss that point, that the attorney is not a doctor, although I have some amount of medical training, because each of these cases, I have to read medical text. I have to understand what I'm dealing with. I'm still not a doctor, but I have to take that file and send it out to a expert, and that expert has to be paid. That expert has to incur, there's costs to that, and they review your file and let you know that it has merits or it doesn't. Either way, that is the determining factor of whether or not an attorney takes your case. So a lot of times those cases, people think it's good, but then it gets returned because no one could pursue it for you, because it's a difficult standard to hurdle to overcome. And I can tell you of cases I've had myself where I had to literally search for multiple experts, get multiple opinions, and then I finally found the right expert who give me the opinion that I was looking for, because not every doctor who reviewed these files for us are reviewing it in a way to give us the right answer that we're looking for. And we can't make the expert give us, a favorable opinion. The expert is going to do that based on their knowledge, based on their experience, based on everything they know about your type of case. Because as I said earlier, it has to be an expert who is also specialized in the area of the same field that the doctor himself is practicing. I've had one case where a client developed cancer and he was only seeing his primary care physician. And the blood work, if the primary care physician knew how to read the blood work, he would have himself referred the client to a specialist, but because an oncologist, but because the primary care physician didn't know what cancer looked like, he didn't even himself understand how to read the blood work, much less to determine based on the blood work that there might be some issues going on in the client's body. He just ignored the blood work and he never referred the client out. So the client later on, when he got really sick and his wife decided, like, we have to get you to another doctor so we can get a second opinion. It's always good to get a second opinion, because you can be sitting with a primary care physician for years and something could be going very, very terribly wrong in your body, but you don't even know what expert to go to. But there are actually some primary care physicians who will review your file properly, recognize that there's an issue and what the issue means. And this is what happened in that case with that client. He went to get a second opinion from another primary care physician. She understood blood work. She understood what to look for. And when she saw that, she recognized that the person had cancer. So she referred the client out to an oncologist who then examined, did certain tests, did MRI and everything, and diagnosed the cancer and was able to provide a treatment to remedy the condition in the client's body. But that is not always the case. And then you have to understand that because the doctor was a primary care physician and he was not an oncologist or wasn't specialized in treating cancer or diagnosing it, there's no way that we could have filed a medical malpractice claim against him, because he's only going to be held to the standard of care required to be given by a primary care physician. And a primary care physician is not trained to recognize or treat cancer. You need a doctor who specializes in that. So therein lies one of the problems. If you have a specific specialized issue, the only way you're going to be compensated for it, it has to be a doctor who specializes in that, whatever it is that the doctor is treating. So, for instance, if you give birth to a child and your OBGYN made a mistake and caused the child to die during child's birth, the only person who could make a determination that that OBGYN was negligent is another OBGYN, not just any doctor, but they have to match specialty in order for the court to make, or anyone to make, a determination that the doctor fell outside the reasonable standard of care or the standard of care that is required by in the medical field to perform whatever procedure is being done. In the case of giving birth to a child, whatever the standard of care is in giving birth, that is what the doctor is expected to do, nothing more, nothing less. Of course, there's different ways you can argue around it to make the doctor responsible, but whatever the standard of care, and just note, there's not no one size fit all when it comes to medical malpractice. So you cannot just say, well, this is the particular as you know, medicine changes all the time, procedure changes. Before there was the advent of robotic surgery, everything was done manually, but now there's robotic surgery. So the standards has changed now. And there's different positions that doctors are required to put patients in for certain types of procedure, medical procedure. Once they're performing these robotic surgeries, the doctor is expected to understand and be trained in how to perform the robotic surgeries. And in the case of robotic surgeries, they're supposed to be close to being what is called bloodless surgery. So you're supposed to lose less blood when you're doing that type of surgery versus anything else. I've had a patient with an injury. Unfortunately, there was nothing that we could do. The patient came when it was too late. It was outside of the 90 days. The patient suffered a injury to the lung at the hands of a doctor. They performed a surgery on her. It's a very young patient. And it's unfortunate that she's going to have to live the rest of her life with an injury of that magnitude. And there's no way to remedy. She was out of time. Like I said, you got to be within that 90 days. And a lot of minority people tend to go to state and county hospitals. And that's no good, because if they procrastinate on their rights, they tend to lose that right. And then you have to live for the rest of your life in misery. And there's no way to compensate you for your pain and suffering. So guys, you got to be careful. Make sure if you know somebody, if you have a loved one, a friend, family, whoever it is, that suffered at the hands of a doctor, ensure that you give them my number and have them call. My office is located at 455 Utica Avenue in Brooklyn, New York. And the phone number, you see, I have it across the screen, 718-877-3100. I provide free consultation, 15 minutes of consultation, free, and give you all of what you need to make you understand what is happening in your case. And if you don't, you can always ask questions, and we'll be more than willing to explain it in further detail to you. So guys, especially for my West Indian people, Guyanese, Trinidadian, Bajan, all of you, if you believe you had a medical malpractice case and you're looking for an attorney, give my office a call, because I know that, like I said earlier in the show, it's an area that is very restricted. So give me a call and let's get you compensation for your injury. There's one other thing I would like to refer to, which you have to be careful with. Like I said before, not every single injury is compensatable. There are instances where certain types of surgery results in nerve damage. I'm not sure how many people understand that every surgery has risk. So in some cases, you are more likely than not, there's a risk of bleeding out. There's a risk with the anesthesia. There's a risk involved when an incision is made in certain parts of your body. There's a risk of a lot of things happening in a surgery. So you have to know those risks. Ask the doctor about these risks before you agree to take any surgery. Make sure you understand that it's not as simple as it is. And if you assume the risk, because if the doctor sat there and he explained that, hey, this is the situation, this might happen to you, and you understood and you consent and agree. And let's say there's something unique about you. Let's say you had a similar surgery before, and the doctor tells you if you do the surgery the second time, you may end up with severe nerve damage. You might not be able to feel anything in that part of your body or any of those things, and you still assume the risk. I hope you understand that if you end up not being able to feel on that part of your body, you might not be able to sue that doctor after that. So be careful and know the risk involved in every single thing that you do. Understand your rights as a patient and know for sure that if you got injured, seriously injured, you need to get to the phone and call. Don't wait for the last minute, because if you wait, let's say the statute is running out in a couple of days, and then you call me, your chances of me wanting to, or any attorney, as a matter of fact, wanting to take that case 3 days before the statute will run out, or a week, it's less likely, because there's a lot of things that goes into drafting a medical malpractice complaint and getting, if it's in New Jersey, you have to get the affidavit of merit. And that takes a lot of time, because you have to sift through numerous specialists, people who are specialized in that field, to ensure that you find the right one. All right, guys. Again, I want to thank you guys so much for joining today, this show, The Law and You. Thank you for all your support. So if you have learned something from today's show, what I would like for you to do is press the like button, guys, and share this live. Share it as much as you can. Thank you so much to the people in Brooklyn for all your support. I do appreciate that, and I would appreciate you sharing this video today. Thank you so much, and I will see you again next Saturday, the same time. I'm here every Saturday at 4 p.m. So join me live every Saturday at 4 p.m. Let's discuss various legal issues that might be affecting you. Today's program was brought to you based on medical malpractice issues, guys. Thank you. Enjoy the rest of your weekend.